All right, in this video, we're going to talk about the two theories of constitutional interpretation. So you're going to have judicial restraint and judicial activism. And this is going to be how a Supreme Court justice or a judge is going to go about interpreting the Constitution. So the first is judicial restraint. And this theory is that the court should seldom use judicial review and defer judgment to the legislative and executive branches. Okay, so justices that adhere to this philosophy of judicial restraint are going to believe that judgment should be left to those elected branches of government, okay, so legislative and executive branches, and that the Supreme Court should only use that power of judicial review to invalidate laws or executive actions. They should only do that when it's necessary, absolutely necessary. So the idea is that that judges should be cautious in overturning laws that go against the majority, okay, because there's potential undemocratic consequences to going against the majority. The idea is that justices are legal specialists, not policy specialists, okay, so they were put on the Supreme Court to follow the law, okay, so not policy or opinion, but the law. And they should consider the intent of the Constitution and its framers, okay? So with judicial restraint, it's that idea that justices should use judicial review as infrequently as possible. On the opposite end of the spectrum, you're going to have judicial activism, okay? And this is a philosophy that justices should be willing to overturn laws when necessary, sometimes creating a bold new policy, okay? So this is where justices are going to be interpreting the needs of the times, okay? So things have changed, society changes from the time that the Constitution was written. Okay, so sometimes laws might have to be overturned. So this philosophy recognizes that the legislative and executive branches might not always act fairly and precisely because they are elected. So this holds that the judiciary should use that power of judicial review to protect the rights and liberties of individuals and minorities. So the court is going to be able to protect the minorities who might not have the respect of those other branches. And because the court is free from the concern of popularity, the court can act when other branches cannot. Okay, because again, they're not having to worry about being elected. So judicial activism is the philosophy that when necessary, the court should use that power of judicial review to set this bold new precedent. So two court cases that are good examples of judicial restraint and judicial review would be Plessy v. Ferguson and then Brown v. Board of Education. So in Plessy v. Ferguson, this is a case from 1896, the court is going to rule that separate facilities for whites and African Americans is constitutional so long as those facilities are equal, okay? On the opposite end, Brown v. Board of Education is going to overturn the idea of separate but equal, okay, and desegregate schools. So Plessy v. Ferguson is an idea or is an example of judicial restraint, okay, so not overturning precedent, upholding that law of separate but equal, whereas Brown v. Board of Education is an example of judicial activism because it's overturning that Plessy v. Ferguson ruling, okay, in 1954, and it's setting that bold new precedent of desegregation, okay? One thing that I do want to point out in terms of judicial restraint and judicial activism is don't confuse that with conservative and liberal, okay? So don't just assume that because a judge uses judicial restraint that they're conservative, and because a judge uses judicial activism, follows that philosophy, they have to be liberal. That can sometimes be the case, but there can be liberal justices who choose to practice judicial restraint when it comes to how they look at the law, okay? So don't confuse those. All right, and the last slide is going to be the limitations on power, okay? So how the other branches can check the Supreme Court. So we've said that the court has the power over to check the other two branches with that judicial review, okay? So they can check to make sure the laws of Congress are constitutional, to make sure that executive actions are constitutional. Okay? But there are ways that the other branches can check the court. So the first is one we've already talked about. The president nominates judges, and then the Senate has to confirm those nominations. We've said that Congress sets the size of the court, and they establish those lower courts, okay, so the district and federal courts. Congress can write legislation that impacts court decisions. The court has to turn to other branches to enforce their rulings. So remember, the court does not have any kind of financial power or military power, so it has to depend on the executive branch and the legislative branch to make sure that its rulings are enforced. And again, we talked about that legitimacy of the court and how public opinion, what people think of the court, can play a role in how closely the court's decisions are going to be followed. Okay, so that is the end of our judicial unit videos.